Hi, I'm Brad Bryan from Los Angeles, and I'm here to give you some tips on focus groups and mock trials. The first thing I want to say is to talk about what I think is a misconception about focus groups. I think many people think of focus groups as being some elaborate procedure that can only be afforded by well-financed political campaigns or wealthy corporate litigants, and that's just not the case. To understand that, it sort of goes back to what is a focus group. In my view, a focus group is any time you present your facts and your arguments to a group of people who are not familiar with the case. That's a focus group. And so people who are not well-financed political campaigns or wealthy litigants can do focus groups. You can grab 2 secretaries, 2 messengers, 2 other people from your office who have no familiarity with the case, and you can sit down in a conference room and present your case. That's a focus group. Get their reaction to your case, to your facts, to your arguments. Now, obviously, there are more elaborate, more expensive methods of doing focus groups. You can hire jury consultants. You can have jurors who are picked demographically. You can have computers that the jurors hold and give you instantaneous feedback with. That's a very effective focus group. But I'm saying that all litigants and all lawyers can use focus groups. You can spend next to nothing. You can spend $50,000. In either case, the key ingredients are the same. That is, that you present both sides of the case effectively and strongly. If you're doing a mock trial where you're having 2 lawyers, make sure that the other side is represented at least as well as you're representing your side. And make sure you take steps to let the jurors talk and hear them deliberate and hear them react to your case. Now, the purposes of focus groups and mock trials are many: to help you identify and develop your themes, to help you organize your opening statement and your closing argument, to help you evaluate the case for settlement. I'm going to talk very quickly about 2 other purposes. One is to measure the credibility of your witnesses, and the second is to test the commitment of the jurors either toward your case or toward the other case. I've done focus groups where I've had 24 people in there, and I give an opening statement and closing argument from both sides to both groups. I let 12 of those people go deliberate. I then take the other 12 and I bring in the critical witness. And I do a direct examination and a cross-examination of that witness. I let those 12 people go deliberate. And that way I see whether there's any difference in the reaction of the jurors. I've done this in criminal cases with my client, where of course it's critical to determine whether your client is going to exercise his or her right not to testify. But you can also do this in a civil case to evaluate how the critical witness comes across, whether if he's out of the district, he or she is out of the district, whether you want to use a videotaped deposition instead of live testimony. The other practical tip I wanted to say is it's important to measure the commitment of the jurors either for or against you. It's not enough to do the focus group and have the jurors vote. You need to see them talk and listen to what they say, because if the vote is 6-6, that's one thing. But if it's 6 people who are strongly against you and 6 who will just sort of go with the majority, those 6 who are weakly committed will easily move to the majority. You have to decide whether your case is the kind of case that will bring out strong or weak commitments from jurors.